everybody, and welcome. My name is Ethan Michelson, and I co-direct the Center for Law, Society, and Culture. The center is very happy to take credit for helping to bring you this event, especially since it exemplifies the best of law and society research. The reality, though, is that Jody Madeira and the law school deserve all the credit for putting this really excellent event together. I'm nonetheless honored to chair this really exciting panel on Professor Madeira's new book, Killing McVeigh, The Death Penalty and the Myth of Closure, which came out this summer from the NYU Press. We have the very good fortune to have Barbie Zelizer from the University of Pennsylvania's Annenberg School of Communication here. You may recognize her already. She's here on campus speaking in the Patton lecture series and happened to have supervised Professor Madeira's PhD dissertation. So she will say a few words at the outset. Our panelists who will comment on the book are John Lucades from the IU Department of Communication and Culture, Ed Linenthal from the IU Department of History, and Susan Bandas from the DePaul University College of Law. All four members of this interdisciplinary dream team panel are renowned scholars of collective memory, which is often produced and reproduced discursively, as we'll see, commemoration, trauma, and emotion. Each will speak for approximately 10 minutes before Professor Madeira will respond. And if all goes according to plan, we'll have 20 minutes, maybe 30 minutes for Q&A and general discussion. So let us begin. Thank you for coming.
I am, as you were just told, a last-minute add-on to this panel, but I am delighted to be here, and it made me think, having supervised Jody Madeira, I have to look at you while I do this, hold on, that there were a lot of moments in the process where I felt like a last-minute add-on. It's always a professor's fondest dream that their former students will emerge as a colleague, both in rank, i.e. they will graduate, and in topic and interest. And I say that with the highest regard for Jody's work. She came to Annenberg an absolute ball of fire. She walked into the school, walked into my office, told me, didn't ask me, never negotiated with me, told me what she wanted to do. And I had to follow her lead. I don't do that so well. So we had this wonderfully productive relationship as she moved from a very early and very insistent interest on the McVeigh, on the Oklahoma City bombing, on the McVeigh execution, on the question of trauma and the collective imagination. And she came in, it was just, as they say in the Midwest, a hoot to supervise her, because she came in, she would come in, I would tell her that something was off about something in her dissertation, she would disappear, she would come back 24 to 36 hours later with another 30 to 40 pages of text. And I used to think, when does this woman sleep? When does she eat? When does she have a life? And she did, of course. And the amazing thing is that the 30 to 40 pages of text were always stellar. They were always remarkable. She needed very little supervising. What she needed was harnessing, which I tried to do as much as I could. The interesting thing, however, that thinking about collective memory and this, the book that eventually came out of this dissertation, is that in the beginning, Jody and I were talking about this the other night, it wasn't really a project in collective memory. It was a project about trauma. It was a project about narrative, about language. And the wonderful thing is that collective memory kind of bubbled up inside of it as a way of making sense of the data as she collected it. So I want to herald this occasion. I am so grateful to be here. And I want to tell you, you gotta all go and get the book.
Well, I am just delighted to be here to talk to you about Jodi Madera's book. I have been eagerly waiting for this book for a very long time. It explores so many issues that I care about deeply and that I think you all should care about deeply. Specifically, first of all, the debate about the role of victims in the criminal justice system, the whole idea that after 200 years of having an adversary system, victims have become another part of the system, and yet the idea of exactly what part they should play in the system hasn't been very well theorized. So that's one thing. Secondly, the notion of why we have a death penalty, what we're trying to achieve by the death penalty, and this idea, relatively newly minted idea, that one aspect of the death penalty is the notion of therapy and giving closure and healing to victims and survivors. Thirdly, and this is where Jodi and I have really came together and why we have been so closely involved in each other's work for so long, the issue of the role of emotion in the legal system. And if some of you are first years, or perhaps even if you're in law school at all, that might sound like an oxymoron to you, emotion in the legal system, but this is something that Jodi and I have both been writing about for a long time, and something that the book really examines in some extremely productive contexts. So what I want to do in my short time is to highlight 3 contributions that I think Jodi's book has made. And I should also say, by the way, that as someone who doesn't do empirical work of my own, I'm absolutely in awe of Jodi's ability to establish and nurture the kinds of relationships that she must have needed to establish and nurture in order to gain the trust and maintain the trust of the people that she wrote this book about. So here's what I want to focus on. First of all, I need to, or I would like to introduce you a little bit to the state of the debate that Jodi entered. This was a very polarized debate, this notion of whether a sentence of death or an execution ought to be imposed partly in order to bring closure to the people who have lost somebody they loved to a murder. And so just to give you a little brief bit of background, this is a newly minted concept. It really didn't exist until the early 1980s. It was a byproduct of the victims' rights system, which was gaining a lot of ascendancy in that time period. As Frank Zimring showed, Jodi talks about this, it sort of burst on the scene in the 1980s and grabbed hold not only of the popular imagination, because now you read about closure everywhere, but also of the criminal justice system, which started making all kinds of changes in order to try to ensure that closure was something that survivors and family members could obtain. So suddenly it was part of the discourse, and not on an abstract level either. We were starting to cut back on habeas, we were starting to exhort juries to impose the death penalty in order to grant closure, and so forth. So this is a question that has both the abstract issues raised with it about what the victim's role is in the justice system, and the very concrete changes that were being made to the system. So it was a polarized debate. It has been and continues to be a polarized debate, because for those of us who oppose the death penalty, closure is a concept that's been so poorly articulated and has had so little empirical evidence to come along with it that it's been pretty easy to reject it. On the other hand, for those who are in charge of assuring the well-being of victims and survivors who've gone through horrific tragedies, it's very hard to turn away from it and to say, I'm going to deny you this closure that you need. So where do we come together on this? And these discussions about exactly what closure actually means, how we can sort of disentangle it and figure out exactly what it requires, what it is that victims' families really do need, and whether the justice system ought to have a role in doing that, and if so, how to make sure they can do it correctly, was a discussion that didn't really take place very often at all. Instead, you had these two polarized positions. And so Jodi's book does a number of extremely valuable things to move this conversation forward. It forces the reader to wander afield from these polarized positions and from these grand abstractions about closure. And it shows us, I think, how foolish it is to make assumptions about victims as a group, or to rely on stock imagery about how victims feel and what victims want. And it shows us a number of things about closure in a very particular and concrete context. First of all, it shows us that closure is not a landing place, it's not a static state, it's a process, it's an ongoing process. And Jodi's insights and observations about the nature and texture of this process are truly original. Her notion of closure as a process of creating coherent, meaningful narratives is really helpful and original. And it takes closure out of the realm of a one-size-fits-all state, and it makes it clear that it can take many forms for many people. It also rejects the view of closure as a passive state, something that just sort of is visited on a victim, and recasts it as something that happens to people that have their own agency and their own will. It's a very empowering idea, that people do make choices, that victims need assistance from the justice system, but ultimately they are going to heal themselves in the way that works best for themselves. I think that this notion of narrative or storytelling is really helpful on a practical plane. As I also have argued, along with Jodi, closure is a term with many possible reasons. And when the legal system starts making changes that involve capital punishment, where a bunch of lives are at stake, and a lot is invested in many ways, it's important to be very precise about what meaning we're relying on. And so Jodi says narrative making can function here in a couple of capacities, and these are two different capacities. It allows victims and survivors to heal, but it also allows them to bear witness, to make a public statement about what happened and what the meaning is and what was lost. And if you think about it in terms of the practical connotations for the legal system, the notion of helping a survivor to heal and the notion of allowing a survivor to bear witness are two very different things that might require two entirely different responses from the legal system. The first might require some sorts of therapy, some sorts of social work, some sorts of training or retraining for judges and other actors. The second might require a victim impact statement or some other opportunity to get up and speak out loud. So until we start disentangling all these meanings that have gotten clumped together, we can't really make an informed choice as legal actors about what ought to follow from this notion of closure. All right, so there's so many great people waiting to talk, so I'm going to just sort of try to sum up here. The other thing that I wanted to focus on that Jodi does is she situates this notion in an institutional context, or in a complex web of institutions, really. And when you think about emotion in law, one of the critiques that I've often had is that the law tends to talk about emotions like remorse or shame or you name it, as if they are just things that you can put somewhere, that you can make people feel, as if the context doesn't matter. And what Jodi shows us is that two intertwined things. First of all, that what people feel, whether people feel something called closure, has a lot to do with not only the various interlocking legal institutions, like the jury system and the trial system and the prosecutor's office and so forth, but other institutions as well. The media, community, interest groups that come together, collective action groups. So the richness of Jodi's account really shows us that the setting and the institutions help shape not only how people get the closure they might need, but it also helps shape what people believe they should feel. It actually tells them that they should feel something called closure, and creates a need. So there's a feedback loop there. It gives them stuff, but it also tells them what they ought to feel. And I think that Jodi's account really does a beautiful job of illustrating that. So I will just close by saying that there's no easy way to summarize the lessons here. I thought that the chapter that Jodi wrote about the victims' families watching the execution of Timothy McVeigh, waiting to feel this closure that they were told that they were entitled to and would feel and looking for something in his eyes that would explain to them the meaning of the loss, and in most cases not getting it, was just one of the most powerful things I've read in a very long time. And I guess I would say that as much as abolitionists like me would have hoped to derive a simple lesson from that, I appreciate very much Jodi's refusal to simplify and her meticulous, complex account that she provides us in this book. Thank you.
I think it's you.
Is it me?
You.
Well, I'm really happy to be here, and it's been a real pleasure for me to be a conversation partner with Jodi over the past few years, over many lunches at Laughing Planet. I came to IU in the fall of 2005, 4 years after having written a book called The Unfinished Bombing Oklahoma City in American Memory, which was released a week before 9/11, which was a very interesting time for me, as you can imagine, and didn't know Jodi, didn't know about her book, but was so very pleased to learn about what she was doing, and it really took off in many ways from what I had done, which was to look at the impact of an act of domestic terrorism on an American city in a whole variety of ways, and then dealt, as we've heard, in this very compelling way with the impact of this on the legal system, and I think the best sensitive description about the dynamics of the trial, family members' engagement with the execution. So both of these books are clearly stocking stuffers for the whole family. with the holidays coming up, you should probably go line up now. So I want, since I don't know anything about law, particularly in this room, I don't know anything about law, to think back and think about some of the larger issues that emerged for me, both talking with Jodi and reading the book. First of all, I'll say to you that if I was king of the world, and based on my close analysis and data I've accumulated, I'm the only one who's in favor of that anywhere, I would banish the term closure and healing process from the English language. I think they are obscene. I think they are the worst example of psychobabble, and I think they do violence to the experience of people who have been through acts of violence. They diminish our understanding of the power of evil. They sanitize and domesticate and familiarize that which should not be at all. And it's part of a whole set of assumptions that we make, I think, as Americans, and perhaps somewhat beyond. One, that memory is by definition healing. Where in the world do we get that idea? That memorials and memorial making are by definition healing, constructive, that bring communities together? Well, they can. They also rip communities apart. And Jodi and I know many of the same people in Oklahoma City, and a good many of them thought that these terms did violence to their experience and rejected their use angrily as they sought to engage in, and it's a term that can be used simplistically, but it's also a term that can be used very thoughtfully, in the new normal. This is not a matter of reaching closure. It's a matter of integrating into one's life these devastating events that are so subversive to all of us, of our notions of civic community, of humanity. I mean, one doesn't use the term closure to talk about Holocaust survivors. And anyone who thinks that memory somehow is healing over time should look at the statistics of Holocaust survivors that commit suicide decades later because of the despair that they feel that the world has learned absolutely nothing. What's the word closure going to mean to them? Or healing process, that we somehow contain these experiences in this regular process? This is not how this stuff works. This stuff is like a serpent, and it coils back on itself, and it opens up again. When Oklahoma City took place, the first set of files that I went through at the Oklahoma City National Memorial Archive, which was in this big warehouse at the time, were thousands of unsolicited memorial ideas from all over the world. Many of them were from people whose own experiences with violence had been awakened. Battered women, victims of rape, veterans of war, on and on and on. There was no sense of closure in their lives. If we look at European countries, often mourning is a part of who these people are. It's not something you jettison, it's a part of who you become. But here, what is it a sign of? It's a sign that you are ill, in need of treatment. So you transform narratives of political violence into illness narratives. And of course, to heal, which is an incredibly politically loaded term, and to not think about the genealogies of terms like PTSD and healing process and healing, and what they reveal and what they hide, and whose interests are being used when they are used, is really to miss the boat on this stuff. When these terms are used, they hide so much. People in Oklahoma City who angrily rejected these terms turned to the arts. They turned to music, they turned to poetry, they went on retreats where they would draw, where they would do all of these things, and they refused to let these illness narratives control their lives. Because if you have an illness narrative, then you turn to the high priests, mental health professionals, to unlock the secret of what's inside. It's very interesting to talk to mental health professionals in Oklahoma City who talked of the people who came in to ostensibly help others as disaster vultures and did more harm than they did good. I will commend to all of you a wonderful book by Jamie Calvin, K-L-V-E-N, called Working with Available Light. It's a fantastic title, and it's a very sensitive account of his engagement and struggle in his family with the sexual assault of his wife, and the violence that was done to her by the narratives that were being imposed upon her by other people. Redemptive narratives, triumph of the spirit narratives. I mean, this is one of the real diseases of too much Holocaust literature. Look on the back, and this is a book about the triumph of the spirit. Well, it's also about the degradation of the body, but never mind. And one of the things that Jamie says in this book is that we don't have in this country language to talk about the chronic affliction. And this became so clear in Oklahoma City when you had reporters going up to family members and, well, now that the funeral of your 2-year-old is over, have you reached closure? I mean, first of all, what's newsworthy about the response that we all know is coming? This is toxic gossip at its very worst. I mean, the only kind of sick, newsworthy response would be, well, you know, yeah, my 2-year-old's dead, but hey, stuff happens. I think I'll go out and play 18 holes today. I suppose Geraldo might really like to do something with that. I mean, what do we expect to hear? And what kind of comment is that? It's a kind of violence against people's experience. Well, so Jody's heard these rants many times already. Now you get to hear them. So let me close just by saying a little about, because it was striking to me after 9/11 how this same process happened. One of the things that I wrote about was a whole variety of different narratives that were imposed on what happened in Oklahoma City. There was a kind of narrative of civic renewal. Yes, it was horrible, but, all right, there's a collective effervescence that comes over a community after trauma. We're all in this together. Our blood is all the same color. So it was just interesting. And there was a tremendous period where people in Oklahoma City, they proudly call it the Oklahoma Standard, came together. Stories of poor people coming up in jalopies, bringing sandwiches to the rescue workers, all of this. So I asked the African-American city councilwoman, I said, well, what about this sort of, our blood's all the same, and now we're all together, and this horrible event can bring us together. This is a cliche that I've heard for far too long in my own consciousness, starting with JFK's assassination. All these assassinations and all this violence is going to bring us together. Well, it's just nonsense. So I asked her, and she said to me, she just smiled. It was a great moment. She was a wonderful woman. She said, well, for a few weeks there, we did talk, and then everybody went home. Okay? So there was this narrative of civic renewal. Yes, it was horrible, but we've heard this after 9/11. There was a narrative of religious redemption in which all kinds of religious resources were mobilized for all kinds of things, questions about evil, wonderfully interesting and revealing comments about American innocence, right? Lots of stuff about how could this happen in America? How could this happen in America? Really? Are you kidding me? Because clearly this is the first act of gratuitous violence that America has ever seen in 1995. There was the therapeutic narrative, which Jody has focused on, and it struck me immediately how powerful this narrative was and how this language of the mental health community trumped so much else and diluted so much authentic experience. And then there was, to my mind, and you can tell by the title of the book, The Unfinished Bombing, there was the narrative that I thought among the truest to the event, and that was the toxic narrative. That these are not events that end. These are events that can and sometimes cannot be incorporated into people's lives. But the toxic impact of this stuff is always present in any number of interesting and revealing ways. And this was important to me because I thought, very much like Jody, that our books, while works of scholarship, and we both worked very hard with a kind of consciousness of the critical distance needed to do this, also had to be true to the power of the experience that we were writing about. And so if terms like closure and healing process come into the regime of law, I hope it's done with a subtlety and a smartness that it's not present anywhere else. I remain to be convinced that that will be the case, but I suppose we'll see. That's all.
Thanks for making it so easy to follow that up. I too, like Susan and Ed, am delighted to be here to talk about what I think is a truly important and remarkable book. Also, like Ed, and unlike Susan, I am not a lawyer. But I have never believed that a lack of formal training in the law should keep citizens from thinking about and talking about the law. So recognizing, where my ignorance comes from, I will have a few things to say along the way. What I would like to say, what I would like to do is just focus my attention very quickly on what I think are three important contributions in the book, and then we can talk about them in more detail later if folks like. The first and most obvious, for me, contribution is that the book creates and organizes an incredibly important archive of materials. Primary here, of course, are the interviews with the victims and survivors of the Oklahoma City bombing. And in fact, I think this material is so important, and like you, I'm in awe of the ability to collect it under what have to be incredibly difficult circumstances. I hope that material can become available to other scholars to be able to review, because my guess is that as powerful as Jody's reading of that material is, there are more stories to be told here, and there's more to learn by looking at that material. But I think the archive is important as well, not just as a historical record of a tragic and catastrophic event, in as much as it is that, but also because it provides something of a self-contained library, or a laboratory, for observing the complex process of collective and cultural memory formation in situ and over an extended period of time. And I don't think that we've done that in a lot of places. And if the book only did those two things, I think it would be worthy of inclusion in every library in the land. But it does much more. The second contribution, and I think it's an extension of this first point, is that it offers what I would call a long argument for us to consider the complexities of cultural formation, or of cultural memory formation, or collective memory formation, as it operates in two different but interacting formations. And let me just briefly outline those for you. The first recognizes what I would call the difference between living memory and myth. Living memories, I would argue, are vital and adaptive. Like all living things, they are in constant flux and change, more concerned with the relationship between the past and the present in a kind of a presentist sense than with the past for its own sake. And we see this in the book, right, as the memories attached to McVeigh and the Oklahoma bombing warp and woof with time and change in a whole variety of ways. The potential danger, I think, is when we convert from living memories to what I would call dead memories that are either calcified or petrified, rather like dead metaphors, right? They become static myths that exist in and of themselves. And I'm thinking here of things like our memories of events like, I don't know, the Bunker Hill Massacre or the Alamo, right? At one point in their histories, they were vital and powerful stories, adapted and used to negotiate the social and political landscape. There was a time when we regularly stood up and gave Boston Massacre orations, right? And they weren't just epideictic occasions, but in fact they were designed to engage with the political landscape, to create identity, to animate agency. But now, of course, they barely exist as stereotypical moments in history that we barely pay attention to. The second formation recognizes the ways in which living memories operate in two competing registers, and I would call them dialogical and rhetorical. The dialogical acknowledges the sense in which cultural memories are never entirely personal, but emerge in dialogue with others in a kind of I-thou relationship, as they negotiate all manner of competing tensions prompted by negotiating the relationship between the past and the present. The rhetorical, on the other hand, acknowledges that the memories at stake are constantly being used to craft identity and to animate agency and action. Now, this isn't Jodi's language, and I don't think she teases out the argument in such terms, but I do believe that there's something like a nascent theory of cultural memory being articulated here that should give us pause whenever memories seem to achieve a too easy stasis that might be cast too easily as closure, right? And here I agree completely with the reserve and reservations and, in fact, outrage at the notion of closure that you've heard others discuss. As one of the survivors put it, I recall from the book, closure only comes with death. And I think that this might actually be right. And as I was thinking about this, I was also watching the presidential debates the other night. And you may recall that there's a moment in the debate when President Obama is making the case that his leadership was significant in this respect, that it led to the death of Osama bin Laden, and he makes the point that this provided closure, right? And I think that, just to double everything that Ed said, that it does nothing of the sort, right? And if it does, more's the pity. The third, and for me the most interesting and maybe the most important argument, concerns the relationship between memory, emotion, and judgment. Judgment, I think, takes a special meaning in a judicial setting, but what I want to say is that not all judgments are judicial. Jodi parses the judicial and mediated judgments, and I think that may be a good way to do it, but it may also be a bit too fine-grained. I think there are even far more ways of thinking about judgment than those two provide. But what she does, I think, allows her to make an important point. And what we see in that point is the tension between the judicial notion of judgment that bends over backwards to avoid even the hint of emotion or pathos, and the mediated version which seems to thrive on it and to mandate it. And what we learn is that for all of its commitment to reason, rationality, and the rule of law, the very best the law can do is to posture by creating processes designed to mitigate the problem by constituting regulative standards. In Jodi's terms, right, it treats emotion as the spice that is added, right? And a huge part of the problem, I think, is that when dealing with cases of this sort, and maybe far more, right, it's impossible to separate judgments from memories, and memories are always inherently emotive. Now, I think this is a good thing. And even though it creates real problems in trying to manage the tension between, say, defendants' rights and victims' rights, that should be a problem for us, and not one that we should be able to solve by taking a too static stand on the myth of closure. So, in any event, what I would say is that this is a book that warrants careful attention, and even if you have only limited interest in the Oklahoma bombings or the execution of Timothy McVeigh, I think it has a lot to say to people who might be interested in a variety of topics. And I am delighted by the opportunity to have read it and to have an opportunity to talk about it. Thank you.
Well, after all that has been said, what can I say, right? I will just say a few comments before we open it up for questions. I can't begin to address the wealth of comments that I've received today, and so I can only hope to tell you, kind of my reaction to a few points that my colleagues have made. This is an area where you have to work with discomfort. Law, legal work, legal scholarship, being a lawyer, being a cultural studies scholar, they're all, for some reason and in some capacity, occupations that deal with liminality. Occupations where you deal with shifting cultural norms, shifting judicial norms, things in flux. Very little is set and very little is set permanently. And so you have discomfort with terminology, discomfort with change. Here in the Oklahoma City context, discomfort with, the conflicts between emotion and reason, discomfort in dealing with actors, judicial actors, police, FBI, that you're not used to dealing with. You have discomfort with dealing with new personalities that you have to work with in order to get answers, and discomfort with the whole context of closure, right? We have closure as a term, and the choice to work within it or to work outside of it is one that in some ways has already been made for us, because to reject the term and to impose a different term such as suture or healing or new normal, no one knows what you're talking about. So the coin of the realm is in fact, is in itself toxic, right? And so in some ways you're doing violence to closure and doing violence to those who suffer from terrorism by continuing to use the term, but what else is there, right? And that is in itself a liminal exercise. So I will say that this is, this work is discomforting and discomfiting all at once. Now, what do we look at in these? Zelizer last night in her patent lecture asked, what do we look at in terms of genocide? Right? Do we look at the victims, the survivors, the perpetrators, the scenes where genocide has taken place? The brick ovens in the concentration camps. What is the architecture of genocide? What is the architecture of terrorism? What is the architecture of murder? And what everybody wants to divorce from that context is the perpetrator. And of course, that's the hardest thing is about doing this work, is that I want to focus explicitly attention on people like McVeigh, on people like bin Laden. And actually, and sadly, my co-conspirators in this project are inadvertent, right? In McVeigh's execution, excuse me, the Department of Justice put his picture up on the closed circuit feed from Terre Haute, where his execution was being carried out, to Oklahoma City, and the picture was literally from his collarbone to the top of his head, staring at people. I'm now conducting interviews with 9/11 family members and survivors, and one of the family members from Boston told how she was brought into the Boston field office with other family members a week after 9/11, and they had huge posters of the 19 terrorists blown up, facing the victims and family members in the front of the room, right, so that they were forced to stare at them and encounter them when they were there to hear a condolence video from John Ashcroft. And so I don't know if I want my partner to be the FBI, right? That seems kind of strange. It also tells me that law enforcement hasn't learned its lessons, right? Even after criticisms they've received about McVeigh's execution, they still fail to have victim assistance, effective victim assistance on hand shortly after 9/11. Their very first priority, one of them should have been developing the system. And so as a scholar, I will, to some extent, be a broken record, kind of hammering the same message home again and again and again until it's heard, until someone finally hears me. In fact, that's what I'm doing. I'm not sure what the lessons are that one can take from this work, but I think closure is different from context to context, and I'm currently taking it to two different contexts. The first is, what is closure like, and how is it experienced by people who do not experience mass victimage, who do not experience their perpetrator in the media every day for 5 or 6 years until they are executed. People whose perpetrators are never executed, or in fact never sentenced to life in prison, or in some cases never convicted. How does it differ in all of those permutations? And the second context is 9/11. Where do you even begin with 9/11? What happens when your perpetrators never get to trial? Then they die in the planes with your loved ones, right? What happens when your perpetrators are foreign and we have to go over there and retrieve them and they sit in a military tribunal? What what happens when, closure spreads not only from the genre of terrorism and murder to the genre of war as well. And so we see how closure is such a polysemous term, and how fluid it is, how fluid emotion is, and how fluid this toxicity is, right? So these questions are still out there. And my aim as a scholar is to make sure that in the words of Ed's book, that we do not forget. So thank you very much for coming. And I think we'd like to open it up to questions at this point.
I don't know if you write about this in the book, but what seems really interesting in this case, and I'd like to hear you or anyone else say something on this, is that ironically the state itself seems to decamp its responsibility. And it seems like a moment of heightened responsibility, being brave enough, forward enough to pull the switch and so on. And yet it decamps its responsibility by saying we're no longer going to deal with this perpetrator, put him aside. Now really a task of the victims to think about closure. And it seems a rather surprising thing is what we really should expect of the state when confronted with such evil is the willingness to constantly name this person and to say this is who this person is and this is the kind of things they've done. If you keep someone in prison, when we think of other horrific murderers who are in prison or who are in prison for a very long time, then the state can constantly, maybe not with the same intensity, engage in that naming. This is a person who did such a thing. But once a person is dead, there's a potential, when we think of great bank robbers and murderers of the 20s and 30s, once they're dead, they can move into a martyrdom status, into a myth status. I don't know if that's happening with McVeigh, but has the state, in an odd sense, turned away from its responsibility to continually engage with a perpetrator in a way, and instead telling the victims, well, you should engage with the perpetrator instead?
Boy, that's a really great question, and I'd just like to say a few things about it, then I'll ask if anybody else wants to contribute. First of all, there's a couple scholars who write on this. They call this term judicial modesty. Well, not particularly this term per se, but a larger phenomenon. And it's basically the willingness of courts to abdicate all responsibility for creating any historical record or anything lasting beyond just a judgment in a specific case. So, for example, in the Holocaust trials of Demjanjuk and Eichmann, you hear courts explicitly disavowing the rule of being an authority. We're not here to create a record. We're not here to create a narrative of what happened during the Holocaust. We're here to sit on in judgment of one man. But the act of judgment on that, of that man encompasses so much, and courts very rarely interrogate that. And I think Mach was clear with McVeigh about his historical, the potential for this as a historical record. So I think he wanted to create as sparse a record, as reasonable, as bare a record as he could. And what happened, of course, well, we had 30 people testifying about the Oklahoma City bombing and their loved ones' deaths. And so I don't think that effort is successful in many instances. We still look upon the Eichmann and the Nuremberg trials as historical records of the Holocaust. So, again, courts, you can't cabinet it off in just that respect. And McVeigh was so much in the media that he was his own spokesperson. What was interesting was that he named himself as the perpetrator over and over and over. And in fact, Ashcroft, put in place measures to limit the access of condemned individuals after his execution. You can only call one time a week for 15 minutes. You can't call certain individuals because the media just poured into his cell, right?
Well, if I understand the question correctly, I mean, a lot of this seems to be in part about victim impact statements, about creating a record, about the bearing witness aspect of the trial. And with Judge Mach, this really gets right to the point of the ambiguity at the heart of the victim impact statement. Because if it's meant as the Supreme Court said it was meant when it upheld giving victim impact statements in capital trials as a way to give more information about the uniqueness of the victim, then I suppose every single survivor who wanted to testify maybe should be allowed to, but there's a question of that you get into all these really strange questions about what's cumulative evidence, right? I mean, if every life is equally precious, then maybe it's cumulative. If every life is unique, then maybe everyone has to get up. The law doesn't know how to do that. Conversely, if it's about the ability to bear witness and to have some kind of therapeutic goal of getting up there, then how does Judge Mage or anyone else, actually I wanted to say this about what you said about the difference between media and the judicial system. I think the judicial system is very much captive to these emotional demands. How do you say, you get to get up and get healing, you not so much? So I actually think that, the legal system doesn't really have the language or the framework to make these sorts of decisions, and there's a real ambiguity about what the system's supposed to accomplish.
But it's also depoliticizing it at this moment, because victims are not going to articulate the political aspects of a crime like this. That's what the state is supposed to do. And if the state sort of turns it over to the victims, then it's also stripping out the politics and saying, well, we're not going to really engage with the political aspects of the event.
But they do implicitly, for example, even by victim impact testimony, restricting, as a practical matter, those who testify to people who are for the death penalty, right? And so you have pro-death victims testifying in a pro-death proceeding, and those who are against the death penalty are left out, even though they're equally victims, equally entitled to these confrontations, these opportunities as everybody else. Any other questions?
Could you elaborate on that just a bit? Are you saying, that people are surveyed before they they give testimony, and they're asked whether they support the death penalty or not? And if they say no, they can't speak?
Yes, and Susan can speak to this as well. The prosecutor's office, works with the family members and actively, evaluates. I don't think they ever ask, are you pro or anti-death penalty, but their sense certainly is from talking with the family members what their preferred sentence is.
Those are strategic, it's not statutory.
It's strategic. It's
Well,
not statutory.
it actually now is statutory.
Really?
In response to what happened in Oklahoma City, where Marcia Kite was refused the ability to get up there and testify in a way that would have made it clear that she did not support the death penalty, there actually is a crime victims federal statute which has no remedial no remedial aspect to it. It's, but no, I think the point, and this actually goes to Barbie's talk last night as well, is that there are these sort of stock victim narratives that are accepted about what you're supposed to feel. So the idea that it's sort of a cry from the heart, a forum in which you get up and say what you really believe, doesn't really pan out that way, because either the prosecutor's office or a social service agency working with them works with them to shape the testimony, and they actually have templates. One of which says, for example, you should express your grief but not your anger.
Any other questions?
Thank you for this. These were 4 terrific sets of responses. Jody, I want to kind of pull you out a little bit on your notion that offering an argument like this is often like being a broken record, because I think it's exactly spot on. It's spot on when any of us do academic research on something that has public impact and don't get heard beyond the academy. So I guess I want to kind of ask, in reflection of the interdisciplinary status of this whole group, how you see being a lawyer together with having a dissertation in communication on something that is profoundly interdisciplinary as a topic. Can you see a certain way in which you're able to use those 2 roles in conjunction with each other?
That's such a dissertation advisor type of question. So yes, and I think the problem was, as an author who's an academic author, but someone who continues to write in this area, continues to do media in this area, I think the question has changed from what we as scholars could do in the past when faced with research in the public interest. And I think this is public interest research, even though the public may not even be aware that it's going on. And it has a therapeutic end in mind. These opportunities have changed. And you have, for example, Twitter, Facebook. You have ample YouTube opportunities to put your message out there. And I think one of the ways in which I see the tension is that having the communication PhD ups the ante in some sense, because you're expected to be more vocal, more sophisticated with media technology. And I think that's the real tension that I see. One of the things that I've always wanted to do, for example, and perhaps this is a line that I'll go to in 9/11, is do a documentary and get into documentary work and start to record these voices. Because even in a book, they're silent, right? But I can bring the message in a way that more people see it. And unfortunately, you have to learn to package the message in other ways other than academic lectures. You have to create sound bites. You have to learn to talk in quote unquote their language, which shaped the reasons why I chose to retain the word closure. And so you have to embrace a lot of things you did not see yourself embracing when you first started a project. I don't know if that answers the question.
I don't know if this is asking for clarification question or asking as a response to criticism, but two different members of the panel said that they get rid of the word closure, or that the killing of Osama bin Laden did anything but provide closure. But obviously there are plenty of examples of the families of 9/11 victims, or just more broadly in crimes you see on local news, people saying that the sentencing or the death of the person who did this harm brought them closure. And I guess what, in your opinion, what's the place of that? Are these people do they have a different definition of what closure is, or are they mistaken, or are you just saying that having closure as an objective for the legal system or extrajudicial system just maybe is too unreliable to be a valid reason?
Well, I've written about this, and I've argued that you can tease apart a number of different meanings. And one of them is, for example, the need to get answers to unsolved problems about how someone died. One of them is that indeed there is a kind of finality that might come for some people with finding a perpetrator, sentencing a perpetrator, maybe executing a perpetrator. In part, these are empirical questions, by the way. Like, how many people do feel that, and to what extent should the legal system respond to it? Some of it might be the sorts of things that, I think Ed and I agree with on, that, this idea of a resting place, that it's all over and you can shut the door, which is what I think victims and survivors are absolutely despise. So, I guess my bottom line would be, the law kind of shot first and asked questions later. It said, let's give people closure without figuring out what they meant by it. If we can tease it apart, then we can be a lot more nuanced and careful about how we should change the legal system, if at all, to respond to different kinds of needs.
Yeah. I would answer it in two slightly, I agree with that, but I would have two trajectories to the answer. One is this idea that the way in which the term is used now in the examples that you gave, oftentimes it's altogether meaningless. It's what people think they're supposed to say, or they've been given a template, right? That's the appropriate response in some measure, right? And this would be an empirical question to find out to what extent they, in fact, then experience structures of feeling that are different or better or whatever. So that would be an empirical question. But the other aspect of it is that, the point I was trying to make is that too often we allow closure to become something like the death of memory, right, or a dead metaphor, right? And I think if it could be kept what I would call like a living memory, right, so that closure didn't mean now we're done with that completely, right? That might be a different thing, but I don't think that's how we deal with it. And I think when I heard President Obama use the term the other day,
he was quoting a victim when he said that.
Pardon me?
He didn't use it. He was quoting a victim when he said that.
He was quoting a victim, but he was endorsing it, right? He was quoting a victim saying this is what in fact happened.
When he was
right?
saying she was endorsing it.
And he was, my interpretation at least was he thought that was a good thing. But even if not, I think the point I would make is that if closure could be kept alive as a living phenomenon rather than something closed off discussion, then that would be a different thing. But I think as Ed suggests, that's not how it tends to work. So it's it's a fraught concept, I would say.
So I'd like to thank you for coming. I'd like to say one more thing, and that's above all, thank you. And I have a number of people who all together in this room I would like to thank. Susan for setting the precedent with your work. Barbie for your tremendous role in shaping everything about this project from cradle to grave, dare we use the word. Even this project will never have closure. You know, Ed, for your first book, which it was like sitting at the feet of the master, reading the book, and then getting the opportunity to consult on you as I wrote my own. And John, whose guidance and wisdom has provided such a mentorship for me since I've been here at Indiana. And my mother, my husband, my secretary, who transcribed just about all of these things when I re-interviewed in 2008. And my colleagues, who have listened to up-teen iterations of McVeigh, and most of all, the students. And you and I are always in dialogue, and you are the ones who come to me with questions, who sit there and listen to me in class as I encounter new theories. And so I learn just as much from you as I hope you may learn from me. So thank you very much, and thank you for coming.